Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Lynn Thompson, a Mississippi construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I would like to introduce the fabulous Lynn Thompson.
Well, good morning or good afternoon to each of you. Wishing everyone a great start to what will hopefully be a prosperous new year. Today, we're going to be looking at Mississippi lien law, which only applies to private projects, and also Mississippi's bond rights, also with respect to private projects. So here are the directions. We'll have questions and answers at the end if needed. And you can see the instructions for that. And here's our agenda for today. Generally, these are the topics that we hope to cover, and we will get started. Okay. You'd really be surprised, but this is a topic, your contract, that surprisingly most people really don't understand what is in their agreement. So if you're going to make one change this year, the one to do is to read your contract and to know it. So many clients come to me with questions, and the first thing I say is, well, what does your contract say? And they're not really certain of that. Whether you are the owner, a project manager, a superintendent, you need to master what is in the contract that you have. It may be your form that you think you're used to working with. It may be the other contracting party's form, but you need to go to school on it before the project starts. There frequently are notice provisions in it that have certain requirements to preserve claims or give notice of changes. And you need to know what your rights and your obligations are within a written document. Another thing, go ahead and request a copy of a legal description of the project where you're going to be performing. You're going to need that later, and we're going to talk about that. And request a copy of any payment bond. Now, by law in Mississippi, if the prime contractor has given a payment bond for a project, you are entitled, upon written request, to receive a copy of that bond within 30 days. So one reason you want to request a copy of the payment bond is to find out if there's one that actually exists. Because if a payment bond exists for a private job, then any right you would otherwise have for a lien transfers to the bond. So you'll know which camp you're in, if you're in a lien position or a bond claim position. So ask for that up front because they do have 30 days to provide that to you. And you're probably going to want it before 30 days runs out. And you certainly don't want to wait until the end of the job or till when payment is questionable to make a request for that payment bond. Okay, next section, securing your lien or your bond rights. There are prerequisites that you want to make sure that you preserve. So you need to know what position you are in relative to the owner. Are you the prime, the sub, a second tier sub, or are you supplying materials to a subcontractor? If you are below a second tier subcontractor, or if you are a supplier to a second tier sub, you do not have any lien rights. Now, if the project is bonded by the prime, the right to make a claim generally follows the same tiers as for liens. So bond claim rights extend to the second tier subcontractor and laborers. Now, assuming that you are within the scope of a contractor that has a lien or a bond right, you want to make sure that you don't lose it. I'm going to go slightly out of order from what you see on this screen and jump to the arrow that says properly licensed on both sides of the contract. Now in Mississippi, you must have a certain a certificate of responsibility if you're going to perform any construction that exceeds the value of $50,000. You have to have that certificate of responsibility, and the other contracting party has to have a certificate of responsibility. Both sides of both parties to the agreement need to have the certificate of responsibility if it is required for their work. I can't sneak around and hire a contractor that's not licensed in Mississippi for in excess of $50,000 and be in a legal contract. If you're not properly licensed, you do not have a lien right. Proper payment to lower tier contractors. This is another prerequisite. In order to have a lien right or to preserve your lien right, you have to be sure you're complying with your payment obligations to lower tier contractors. And substantial compliance with the contract. If you are in default or if you are in material breach of the contract on which you're trying to place a lien and enforce it, then there's going to be a very strong defense that you have not substantially complied. So you need to make sure prior to filing a lien that you are in substantial compliance with your contractual obligations. Now, let's go back to the first arrow, timely notice of labor or materials that are provided. Now, in Mississippi, we travel under Mississippi law under the notion that an owner is entitled to know who is providing work or services on their property. This is designed to give certain tiers of subcontractors and suppliers the right to file liens. Our lien law is, but the lien law is also designed to allow the owner to know the university of entities who could file liens on their property. So that's why the Mississippi lien law provides that if an owner asks the prime contractor in writing to provide a list of all its subcontractors and suppliers that are furnishing labor or materials to the project, and the prime willfully fails to provide that information, then that prime contractor has lost its lien right. Same thing with subcontractors. If the prime contractor asks a subcontractor for a list of its supplier and subcontractors, and the subcontractors fail to do this within a reasonable time, then the subcontractor has forfeited its lien rights. Now, there's nothing to prevent a first-tier subcontractor from voluntarily submitting a list of its subs, and nothing to keep the prime contractor from voluntarily submitting a list of its subcontractors. So you don't have to be asked. You can do it yourself. And a lot of times, first-tier subs and lower-tier subs, they want to give this notice because they want the owner to know that they're out there furnishing labor or materials to that project. Now, if you are a second-tier subcontractor, or if you are supplying an equipment supplier to a first-tier subcontractor, in order to preserve your lien right, you must give written notice to the contractor, to the owner, of your presence on the job. Within 30 days of the first date that you provide labor or materials to a project, you need to have given that notice. And if you don't give that timely notice, then you will lose your lien right. Now, what does this notice have to include? It needs to include the name, address, and the phone number of the person giving the notice. It needs to describe the labor, services, or material that they're providing. It needs to give the name of the project and its location. And it needs to give notice of to whom, like what's the name of the entity or person to whom this labor, services, or material is being furnished. So once you've done that, you should be in good shape to continue and know that at least as of the date you give the notice that you still have a lien right. Now, what if the contract is not in writing? Under Mississippi law, contracts that are not in writing, oral contracts, can still be enforced. In other words, you can still have a lien right even if you do not have a written contract. It's much preferred that you have a written contract, but even unwritten contracts can be enforced. The lien on them can be enforced. Now, ultimately, your ability to recover on your lien or your bond claim is going to depend on the merits of that claim. So you need to keep your project documentation in very good order. It needs to be up to date. It needs to be consistent. And you really need to school your office and field staff on procedures for documenting what's going on. Make sure you've got a copy of the date that you give notice of any commencement of work or delivery of materials. Daily reports are always a good source of project documentation. Project meeting minutes, scheduling meetings or schedules. Keep track of delivery dates, when you've delivered items or materials to a project. If you think you have a claim for, based on performance, you need to give notice of it, notice of the impact, and just generally you need to make sure you've got very good organized internal reporting. And you need to make sure that the folks in the field know how to provide the important information to the office. So ultimately, if you have a lien, you're going to have to win it on the merits. And project documentation is one way of doing that. Now, the right way to exchange a release for a check. You're going to be asked to sign releases to receive payment. And the best thing to do before exchanging your signature for a check is read the release. Read it before you sign it. What date does the release extend through? Is the property description correct? Are you signing a release for the correct project? Are there any claims that you need to preserve that are not covered by the payment? Before you sign the release, read it in its entirety. And if there's some claim that you want to preserve, write it on the release. Make proper notations on it so that it's very clear the extent to which you are signing that release. Now, in Mississippi, we have, they're statutorily approved. They're not, these lien waiver and release forms are not statutorily required, but what you're looking at here is a form that has been approved. So this one happens to be for interim waiver and release upon payment. In other words, this is a progress payment release form. A final payment release would look very similar. So this needs to be completed. It needs to have the property description and the date through which the release is effective. Now look at this portion that says notice. This has to be on the lien release form for it to have legal validity. And this states that when you execute and submit this document, you shall be conclusively deemed to have been paid in full the amount stated on the lien, even if you have not actually received the payment 60 days after the date stated in the release. So in Mississippi, you are presumed to have been paid, even if you have not, 60 days from the date that you sign and submit the lien waiver. Now, if you have not been paid within 60 days, you will lose your lien right. If within that 60 days, you do not either file an affidavit of non-payment, which is saying, hey, I've signed this lease for lien waiver, but I haven't been paid. You have to sign an affidavit, or you actually file a lien within that 60-day period. So a lot of folks are not aware of this. If you are asked to sign a release or lien release waiver that does not have this notice on it, then it is not an effective waiver in terms of your lien. In other words, the 60-day presumed payment will not apply to you. So if the prime or the owner or the subcontractor is using a proper lien release payment, it will have this notice on it, and you need to be very aware of that 60-day presumed payment period. Because when payment is presumed, you cannot go in later, file a lien, and recover on it. Now, There are some lien and bond law traps that you need to avoid. I can't go into all of them, but we'll go into some of the major ones. One is this: what if the contract includes terms saying that you've waived your right to file a lien? In other words, you've signed a contract, and upon the signing of that contract, the other contracting party is trying to tell you, well, you've given up your lien rights. Well, don't worry, you haven't, and don't be put off by that. Under Mississippi law, you cannot be required to waive your lien rights before you've done any work on the project. So don't not file a lien, don't not follow your lien rights just because you think you've already waived them, because you haven't. Now, another thing, very important, watch the clock. You need to calendar the date of every progress payment lien waiver. You need to calendar the date of every last delivery provided or labor performed, and you need to calendar the date of the final payment lien waiver. Now, we've gone over this some already, but the 60-day presumed payment requirement is going to apply. You need to calendar when you submitted it. You need to be prepared to timely file either the affidavit of non-payment or the lien within 60 days, or you'll lose your lien right. So you need to mark all those dates down. The reason you need to calendar the date of the last delivery of labor or materials is because you have to file the lien within 90 days of the last date that you delivered labor or materials or services to a job. So you've got to keep up with your affidavit of non-payment time frame, as well as the proper filing of the lien, which is the 90 days. Now, there's timely notice to trigger bond claims as well. And for a bond claim, if you are a second-tier subcontractor, or if you're a supplier to a first-tier subcontractor, then you have to give notice of your bond claim within 90 days of the last date that you provided labor or materials. Now, this does not apply to first-tier subcontractors, but if you do not have privity of contract with the contractor, you will lose your bond claim right if you do not give notice to the contractor or the surety of your bond claim right within 90 days of the last date that you provided labor, material, or services to the project. So another thing, and this is one of the biggest traps to avoid, is, are you ready? If it comes down to it and you've got to file a lien or an affidavit of non-payment, which is filed in the same way that a lien is actually filed, you don't need to wait until the last day or the last few days before the deadline is going to hit you. You need to have a legal description of the project in hand. You need to have a copy of the bond in hand, but particularly with respect to liens, which have to be filed in very specific places in the county land records where the project is located, you need to know already, where's the courthouse? How much is the filing fee? Who's going to do this for me? You're going to have to, if you hire counsel for this, you're going to have your ducks in a row. Counsel have to go through things like performing conflicts checks. They may require a retainer. You're going to have to provide an affidavit. Is the person that needs to sign that affidavit in the office? So you don't need to wait until the last minute. You need to have your ducks in a row, get your counsel lined up, and know where it is you're going to have to go if it comes down to having to file a lien. Now, the payment bond, you're going to have to know what is required, and it's all set forth in the language of the bond. You have to give proper notice, description of the dispute, the amount that's in controversy or the amount that's unpaid. And you need to make sure that it gets to the right people. All of that will be set forth in the bond. So let's assume that you have not waived any of your lien rights. You're properly licensed. You've provided the proper lien waivers. You've secured either the affidavit of non-payment or timely filed the lien. well, then you are in good shape, and the owner is going to have to deal with you, or the prime contractor is going to have to deal with you, because you have exercised one of the most powerful tools that you have to entitle yourself to payment. Many settlements come because a lien was properly filed and the contractor or the owner knows it is properly filed. So our next webinar will deal with what you do once you have a properly filed lien, but that's a subject for another day. Okay, are there any questions?
Yeah, we do actually have a question that came through. The first question that we have here, it says, does a mold remediation company have lien rights?
They are providing services, and if they are within the tier of any sort of contractor that could file a lien, then I would expect that they would have the right to file a lien. That is a very specific question that would require looking at documents. But I would say generally, if you're providing services to a project, which mold remediation is, and you're providing services to an improved piece of real property, that I would expect that they would have a lien right. That's a very specific question, but generally speaking, I think the answer would be yes.
Okay, wonderful, thank you. And then another question that came through is, can I get the filing, if I have to file a lien, can I get the filing fees included in reimbursed if it does end up going and getting litigated?
Probably so. You can get attorney's fees awarded to you if the court finds that your lien is in good order and you're entitled to those things. So yes, typically filing fees are costs of litigation, and I would expect that if you're successful in your lien, that a court could have the power to award the cost of the filing fees to you. They're not required to, and even if a contractor is entitled to recover attorney's fees or any other costs of litigation, it is always, in the end, up to the discretion of the court to make that award.
Okay, thank you so much. All right, so if anybody does think of a question that wasn't addressed, please feel free to reach out and we will be sure to answer any questions for you. Can you go to the next slide for us, please, Lynn?
Sure.
All right, so who is ready to win a gift? We are testing your knowledge. If you can take a look at these questions, answer correctly in our chat, we will go ahead and send you guys a little prize. So our first question is, how long does a subcontractor have to file a claim of construction lien? And then the second question is, if you are not hired directly by the owner or GC, you are not required to send a notice of lien rights to the contractor, true or false? So go ahead and answer it in our chat and we will send you over a little prize. Can you go ahead and go to the next slide, please? Thank you. Here are some of our SunRay resources to help you stay organized. Go ahead and scan that QR code to access these. You'll be able to stay organized, know your deadlines, secure, and be able to secure your lien rights. So go ahead and scan that so you can access and utilize those tools. Thank you. All right, so please check out our new service that SunRay is offering. SR Receivables will handle your collections for you. We are here to get you guys paid. Next slide, please. All right, so Lynn had already mentioned it, but our next webinar with Lynn is what happens after I file my lien and how do I get paid? That's going to be September 26th. That's a Thursday at 12 p.m. Eastern Standard Time. So if you can, go ahead on to sunraynotice.com/education and register for free and sign up for that. All right, this slide, if you guys don't mind, please go ahead and scan that QR code, give us a review on Google. We really do appreciate any reviews that come through. It helps other contractors kind of hear about us and get the word out about us. It promotes our site as well. So we'd greatly appreciate that. And then I think our last slide, Lynn. All right, and with that, that is all we have for you guys today. Thank you so much for everybody that attended. We hope to see you guys at our next webinar. And Lynn, thank you so much for being incredible. You really did an amazing job on answering questions. And we hope you guys all have a sunny day.